Welcome, and thank you for joining us this afternoon. I'm Amy Dickerson, and I'm joined today by my partner, James Petrungaro. And today we will be focused on the topics of non-renewals, RIFS, and tenure acquisition. So we'll today be providing you a 30-minute overview of the new rules and best practices for 2024 when considering non-renewals, any RIFS, and the rules for acquiring tenure. And we know it is that time of year when districts are starting to prepare for spring teacher staffing decisions, including making assessments of whether any RIFs may be necessary or whether any non-renewals of probationary teachers may be necessary. So while it's always good to have a refresher on the requirements of these various steps and the requirements that control these decisions, it's especially important this year. As many of you are likely aware, Governor Pritzker signed legislation this past August that made significant changes to the requirements for acquiring teacher tenure in the state, in addition to other legislative changes related to RIFs and non-renewals of probationary teachers. So in light of these changes, and given that spring staffing decisions are right around the corner, we wanted to spend some time with you today and spend the next half hour really reviewing the key legislative changes that are now in effect, as well as then provide some key takeaways and best practices to keep in mind. So we will be specifically addressing the new requirements regarding the sequence of honorable dismissal lists that must be shared with the unions, the deadline for when notices of RIFs and non-renewals of probationary teachers must be issued, and then the new tenure rules affecting when a teacher's final year of probationary status may be. We'll review each of these areas and then close with a few best practice tips. If time permits, we will also address questions at the end, so please feel free to post any questions that you may have in the Q&A section. So with that, we'll go ahead and get started. So James, can you start us off with taking us through the new requirements related to issuing those sequence of honorable dismissal lists?
Absolutely, Amy. Thank you. And thank you to all of you for joining us. You're undoubtedly aware that RIF list, or the sequence of honorable dismissal list, as it's stated in the school code, has to be provided to your union 75 days before the last student attendance day. That typically falls somewhere around the end of February or early March. And historically, that list has always been required to include the position that a teacher is qualified to hold. So not necessarily just the position the teacher is in this year, but all positions that the teacher is qualified to work in. And then the grouping of the teacher for purposes of a reduction in force. So when we talk about groupings, we're talking about whether they are group 1, group 2, group 3, or group 4, as that's set forth in the school code. We know that those groups depend on a variety of factors, including whether the teacher is probationary and has been evaluated yet, if they have been evaluated, what the evaluation ratings are, and then ultimately seniority comes into play in a couple of those groupings as well. New for this year, we have a gift from the legislature. Your sequence of honorable dismissal list also now has to include the race and ethnicity of the teacher if it's known to the district. So if you maintain that data, if you have that data for each of your teachers, then you are to disclose the teacher's race and ethnicity to the union with that list. The statute does not set forth what the union or administration are supposed to be doing with that data. It's just a new requirement. We suspect that it just has something to do with providing more data points for you to review at the time of considering RIFs and evaluating the ratings that come as a result of your evaluations process.
And one thing, to keep in mind there, while the statute requires that this list be, provided 75 days before the end of the school term, you want to make sure that you're checking your CBAs. We know that, CBAs sometimes, may give a date certain of when this list has to be issued, or some other, time frame. And if there is an earlier date by when your CBA says this has to be given, despite what the statute says, then you'll need to meet that earlier deadline. So just keep those things in mind as well. With that, we have sort of a welcome change as well from the legislature that will kind of limit some of the need for you to have to count backwards, from these how many days there are before the end of the school term, at least when it comes to the issuance of your notices of non-renewal and RIF notices. So as we reported back in September in an alert, the legislature did make significant changes this year to teacher tenure rules. But in that same act, they also made some pretty straightforward and, we think welcome changes to the notice deadline for RIFs and non-renewals of probationary teachers. So previously, the deadline for when school districts had to give notices of reductions in force to teachers and notices that they were non-renewing a probationary teacher, those notices needed to have been given 45 days, at least 45 days before the end of the school term, which really required administrators to each year count the days, to determine what day that 45th day fell on. So now the legislature changed the deadline to a fixed date of April 15th. So, at least when it comes to those notices, no longer do you need to work on, counting backwards from the last day of the school term, at least for making sure you know when the deadline is for giving those RIF notices and non-renewal notices. So now you just have to make sure that you're giving those notices by April 15th. Again, continue to check your CBAs to make sure that your CBA doesn't contain an earlier deadline for when any of those notices need to be given. If they do, the earlier deadline must be followed. Keep that in mind as well if your CBA has language that tracks the previous statutory language. So if your CBA says that any of those notices have to be given at least 45 days before the end of the school term, and for this year, 45 days happens to be earlier than April 15th, you'll want to meet that earlier deadline, and then perhaps make a note to consider proposing modifying that language going forward, and talking with your union about that. Also, remember that this is the deadline for when teachers must be given written notice of board action to non-renew or RIF that teacher. So any actual board actions, regarding those RIFs or non-renewals have to take place prior to April 15th. So that means for any of your boards that meet later in the month, you likely are going to need to bring the recommendations for any of these actions to your board meetings in March, unless you're planning to do a special board meeting. Again, check your CBAs or any applicable deadlines related to such notices, again, as that may affect what meeting you decide to bring such actions to, when you're thinking about what board meeting you're going to need to bring these to. Now, I did take a look at the calendar, and this year, April 15th, looks like it falls on a Monday. James, I know you and I were talking yesterday about how to proceed if April 15th falls on a Saturday or Sunday in upcoming years.
Yeah, so the school code doesn't give a specific instruction, but there is a law in Illinois that addresses when a deadline that's set forth in a statute falls on either a weekend or a holiday, when's the actual deadline. So in this case, if April 15th falls on a Saturday or Sunday, we get to bump it forward to the next business day. So that would be Monday. The same rule applies for taxes with the IRS in the state of Illinois. So you can, have a kind of a reminder every year that these notices absolutely cannot go out any later than the day we all have to pay taxes. Just another thing to kind of keep in mind is those notices have to go out by certified mail with return receipt requested. But of course, it's a great practice to make sure that we're sending those notices otherwise in maybe a more reliable form of delivery. I just, Amy, it's kind of amazing, just received a holiday card in the mail from a client that was postmarked before the new year, and it just came in the mail yesterday. So we know that the mail itself is not particularly reliable, even when we're sending things certified. So one of those best practices, of course, is to send these things via email, or in the case of a non-renewal or a RIF notice, obviously a best practice would be having that in-person conversation and hand delivering that kind of notice as well.
Yeah, and I think we know from practice too that oftentimes, the way you're working your schedules, you're going to be giving this notice well in advance of that April 15th date. But again, we do need to keep these dates in mind. I do see we have a question, just since we've already started talking about a couple deadlines, just to confirm, what deadlines, April 15th, we've talked about April 15th deadline now and a deadline of 75 days prior to the end of the school year. So as a refresher and review, the deadline for providing that sequence of honorable dismissal list that James was talking about earlier has to be given 75 days before the end of the school term. That deadline, still remains remains in place. Now, starting the school year, when we're talking about actually giving any notices to the teachers who may be being honorably dismissed or non-renewed, those notices actually have to go to the specific teachers by April 15th.
Yeah, so the legislature did us a favor with not having to count days for the notices, but we're still counting days for that sequence of honorable dismissal list.
Great. So James, do you want to take us through now sort of the major change that came with the new law that went into effect at the end of this summer regarding the new tenure rules?
Sure, thank you, Amy. So we've talked about when those notices have to go out when we're going to be issuing a non-renewal. But in order to non-renew a teacher, a probationary teacher, we need to know, in fact, that teacher is still probationary, and when is his or her final probationary year. We have to know that obviously before our decisions are made, whether we're going to be non-renewing an individual. And then we also need to know whether someone is in their final probationary year, because the notice that we send out differs. For teachers that are in their final probationary year, we have to provide a reason in the notice why they're being non-renewed. The reason does not have to include, a 3-page essay, but it has to be a sentence or two summarizing the reason for the non-renewal. Those who are not in their final probationary year, we can simply give them a notice that they're being non-renewed and don't have to provide reasoning to them. Once a teacher attains tenure, though, of course, they're going to be subject to the tenured teacher dismissal rules. And at that point, it's too late to non-renew a teacher. So determining when a teacher's final probationary year is absolutely paramount in this process. And thanks to some recent legislative changes that we're going to get into today, we now have several kinds of tenure to consider. We have traditional tenure, kind of what we've already always considered as being that 4-year traditional tenure. And then there's been a little bit of a change to that. We have accelerated tenure to consider, and then we have portable tenure to consider. So I will kick us off, Amy, with kind of a refresher on traditional tenure and a change that's been made. If we all remember the age-old tenure rule, service for 4 years that are consecutive, a teacher works at least 120 days, that counts as a year towards tenure, then they would achieve tenure after their 4th year. A few years ago, the legislature changed the rules on us a bit, requiring that in their most recent evaluations, the teacher, in order to receive that traditional tenure after 4 years, must have a proficient in the last year that they're being evaluated, and then either their 2nd or 3rd year before that. So 2 proficients in their last 3 years, including a proficient in the final, would get a teacher traditional tenure after 4 years. That's still the rule for anybody who's hired before July 1 of 2023. Now the legislature has added rules differentiating between teachers hired before July 1 of 2023 and those hired after July 1 of 2023. Anyone hired after July 1 of 2023 is not eligible for any kind of tenure this year. So we're going to focus on those who are hired beforehand. If I was hired before July 1 of 2023, I can achieve traditional tenure this year if I'm in my 3rd probationary year, as long as I have 2 overall evaluations. I'm sorry, I'm getting into I'm getting into the accelerated tenure that Amy's going to talk about. This year, if I have a fourth probationary year and I've achieved those proficient ratings in 2 of the last 3 years, I'm going to be in my final probationary year. For those who are hired after July 1, just to give us a sneak preview for years to come, if they've been hired after July 1 of 2023, and they receive an evaluation rating of proficient in the second and third school terms before their final probationary year, then they're going to achieve tenure in 3 years. So the old rule of those hired before July 1 of 2023, it's still 4 years. Hired after July 1 of 2023, it's going to be 2 years as long as they have those proficient ratings. Amy, can you talk about the new accelerated tenure rules?
Yes. So probationary teachers are eligible for accelerated tenure, so to attain accelerated tenure, if they get a certain number, essentially, of excellent evaluation ratings prior to, that traditional final year probationary status that James went through. So that's the general concept of accelerated tenure. Prior to the recent legislative changes, teachers could attain accelerated tenure if they completed 3 consecutive school terms of service and received 3 excellent ratings during all 3 terms of service. Now, for teachers hired even before July 1st, 2023, teachers may attain accelerated tenure after 3 consecutive school terms of service in which the teacher holds a professional educator license, and if they've received just 2 overall annual evaluation ratings of excellent within those 3 years. So if you have had any third-year teacher this year, so we're in their 3rd year this year, and they've received 2 excellent ratings, whether it was during their first 2 years or during the past 2 years, they would be eligible for accelerated tenure after completing this school year, so long as they are not given a notice of non-renewal within the time required. So thus, they would be in their final year probationary status this year. Just so you know, teachers hired after July 1st, 2023, will now be able to attain accelerated tenure at an even more accelerated pace. So those teachers can now attain tenure after completing just 2 consecutive school terms of service in which the teacher holds a professional educator license and receives 2 overall annual evaluation ratings of excellent during both years. So because this does only apply to that rule only applies to teachers hired after July 1st, 2023, any such teachers would not be eligible for attaining accelerated tenure in just 2 years until at the earliest the end of next school year. But again, we're, the rules that I just described for accelerated tenure for those hired before July 1st, 2023, should be kept top of mind as you're thinking through who's in their final year this year. Now, you may also be thinking about, what about that portable tenure provision, right? So there is, a final way teachers have been able to attain tenure is through what we've called portable tenure, which is where a teacher who previously attained tenure at another district could attain tenure at their new district more quickly if they meet certain conditions. So for those teachers hired before July 1st, 2023, portable tenure is still an option. It's still in the statute. The rules have not changed for that. So a teacher who previously attained tenure at another school district could attain tenure at their new district after completing just 2 consecutive school terms at that new district, so long as certain conditions are met. So generally and briefly, those are that they previously attained tenure in a different school district or program in the state, that they voluntarily departed or were honorably dismissed from that school district in the school term immediately before the teacher's first school term of service in the current district, and that they had received In their most recent 2 overall annual or biannual evaluations from the previous school district, ratings of at least proficient, with both of those ratings occurring after the school district's or program's para implementation date. And then they would have had to have gotten the requisite ratings at your current school district, which are excellent ratings. There's also some procedural requirements in terms of a teacher having to give notice as soon as they start at the new school district of what their prior evaluation ratings are. So certainly if there's questions about whether or not someone has met the requisite requirements for portable tenure, certainly, you can talk with your legal counsel about making sure that all of those different requirements are met. For those teachers who have been hired after July 1st, 2023, well, the portable tenure provision still remains in the statute as being applicable to those teachers, because teachers now can also attain tenure by just having 2 excellent ratings within their first 2 years without having to meet those other requirements that portable tenure requires. The portable tenure requirements really appeared to just be, moot for such teachers who have been hired after July 1st, 2023. So we're, mindful of them, but, really, we're going to be focused on those for primarily just those are teachers who were still hired before July 1st, 2023, to consider whether or not those would apply. Again, if it does apply to any of your current second year teachers, then they would be in their final year of probationary status.
Amy, we have a couple really on-point questions, and one of which I think we should really clarify, going back to those RIF and non-renewal notices. And the question is, are we satisfying the rules about delivery if we only give notice via hand delivery and an email, or one or the other of those? And the answer is no. We still have to send those notices certified mail with return receipt requested. I was just pointing out that in addition to satisfying the statute, it's a best practice to make sure we're giving that notice otherwise, because, the statute was written years and years and years ago before we had more contemporary means of communication. So giving it via email, or even having that in-person conversation and hand delivering it, in addition to sending it via certified mail, is a good practice. Go ahead.
I was going to say the statute, does call for specifically what the appropriate and permissible ways of delivering those notices are. I know, our best practice is that when we are helping our districts prepare resolutions for those RIF notices or those non-renewal notices, those resolutions language contains what the way in which those notices are to be given. If it's by certified mail and, personal delivery or email or the like. And those that language should track at minimum what is accepted and permissible by the statutes. So certainly I would make sure that you're working with your counsel as you're preparing those resolutions to make sure that you have that up-to-date language of what's permissible in terms of how to give those notices out, and that whoever then is actually issuing those are ensuring that they are following what then that resolution language says, to make sure that you're giving it in the way that's required by the statute and your resolutions. So with that, we do want to kind of remind you of some typical key tips that we do often want to share as you're thinking about these spring teacher staffing decisions ahead. Before we get into those tips, I do want to remind you that we did issue a alert back in September that does remain on our website under our thought leadership tab that goes through in detail the legislative changes that James and I just went through. So feel free to take a look at that or reach out and we can send you a link to that if that's helpful to review as well, in addition to just hearing our remarks today. But with that, we'd like to leave you with some key tips to keep in mind as you're preparing for staffing changes ahead. So James, what is one of your top tips for administrators to keep in mind when it comes to especially issuing those, making any decisions with regard to non-renewals of probationary teachers?
Yeah, so one tip around those notices that go out is kind of remembering to see the forest and not just looking at the trees when it comes to a non-renewal notice. Um, it is true that the school code requires a reason for non-renewing a final year probationary teacher, and that notice for any probationary teacher who's not in their final year doesn't have to have the reason. But that's not to say that as administrations or boards, we shouldn't have those reasons nonetheless. I run into situations where a teacher who has been non-renewed, is not real happy about the situation, sometimes files a discrimination charge, either with the EEOC or the Department of Human Rights. And then we're having to explain to them why our decision to part ways with the teacher is non-discriminatory and it's, related to a legitimate business objective. We're not happy with their performance. And when I get into those conversations with administrators from time to time, after those discrimination charges have come through, they sometimes are unable to explain the reasoning because they've fallen into the trap. Well, we didn't think we had to have a reason to non-renew a teacher because the statute doesn't require us to put that in the notice. The reality is the reason is there somewhere. We have to sometimes do some work to understand the reasoning. But don't be fooled. The fact that we don't have to give a reason to probationary teachers who are not in their final year does not mean that we don't have to have the reason at all. So let's just keep that in mind.
Yep. And I see a question about, for those teachers hired after July 1st, 2023, do they need written notice after their third year now if they are non-renewed? So, I'm wondering if this question may be just again, whether or not they need to be given a written, reason, a reason for that non-renewal notice. And that answer is generally yes. So for our teachers hired after July 1st, 2023, if they're in, they'll be in their final year of probationary status as a third year, so long as they've got those otherwise, those requisite evaluation ratings. And then if they are non-renewed in that third year as their final year probationary status, then they will have to be given a reason for that non-renewal in that notice, as James said. So that's really why it is, again, so critical that we do keep in mind when these final years of probationary status are, especially if you're going to be giving a non-renewal notice, to know when that reason has to be given in writing. And so with that, perhaps as no surprise, since I've already said it twice during this webinar, my general tip really would be to keep in mind that dates are important and your deadlines are important. And as you, are thinking about any decisions now that you may need to be making in February or March, to really look at the calendar now, look at when your meeting deadlines are, to make sure that you are keeping track of when any required notices or decisions need to be made so that you're complying with all of those applicable deadlines. You want to take note of any legally required dates that are applicable to the RIF process or non-renewal notices, as well as any applicable dates related to, evaluations as well. And then in addition to those that are required by statute and the regulations, also, again, be sure to check your CBAs as well as district evaluation plans for any applicable dates that may be in there as well that may not necessarily track the statute, but may require require you to do something earlier. And you want to incorporate all those then into your plans for the months ahead, and for your determinations for, which particular board meetings you're going to be bringing any recommended actions to the board, when you're going to be having some of these conversations with your union or the affected teachers. And that I think will help you then, remain organized and make sure that you're giving yourself enough time to make some of the decisions that you may have to make. So with that, I see that we're at the end of our time. Please do reach out if you have any lingering questions that we weren't able to get to today, and we're happy to still continue the conversation. And we again just thank you for joining us today, and we hope you have a good rest of the day. Take care.
Thank you all.